Hello, everyone. Welcome to Jamaica 411. Thank you so much for joining me for this special news item. This concerns the judicial review application that was made by the Prime Minister Andrew Holness. There was a ruling, and the judge, Justice Althea Jarrett, granted certain orders and refused certain orders. And we're going to be bringing that information to you with very little comment. You know why? Because me no lawyer. So what me going to do is ask Sister Dion to see if she can explain some of the things them to we. What you say? You approve? Well, she's a lawyer and she's willing, so why not listen? Anyway, please remember to give the video a thumbs up. Go ahead and do so from now, please. As well as subscribe if you're with me for the first time. To my many subscribers, you know the ropes, right? You're going to go ahead and give the video a thumbs up. You're going to also share and then return so that we can get down to business. Of course, everyone, you're quite welcome to leave your comments in the comment section, and my peeps know that already. So now that you guys are back with me, let us get down to business. So I'm going to play what Dion had to say on the matter. I am going to read what the Gleaner said, or the Observer. For sure, I'll read what NNN has said, and then we'll see if we can make head or tail of what is going on. I also have the judgment, and I'll read part of it to you, but only after all of them lawyer people explain certain things to us. All right? Great. So let's listen to Dion now, and then I'll rejoin you afterwards.
Now, I did a whole series of videos going through the Integrity Commission's report on the Prime Minister's statutory declarations. You can check those out. A statutory declaration is when a public servant is required by law to make a list of all his or her income, assets, liabilities. That information has to be filed with the Integrity Commission. And the Integrity Commission, because you have to file that every year, they use it to keep track of your wealth and whether your income can legitimately explain your wealth. If they're satisfied with what you filed, then they'll certify it. So that's the cause of all the problems here. They haven't certified the Prime Minister's declarations.
All right, so let me butt in here a bit and remind everyone that Andrew Holness has been in the Parliament since 1997. This particular Integrity Commission is relatively new. It was established by law in 2017. It was Andrew Holness's government who passed it into law, but it was not the Andrew Holness government that brought the bill to Parliament. It was the PNP, and Mark Golding was the Minister of Justice. That's why he's owning it. Don't know if he still own it, but he's owning it. So what is the Integrity Commission? This Integrity Commission is an amalgamation of 3 other bodies that were investigating corruption. And it was thought that rather than have 3 separate bodies, not talking to them one another, right, investigating more or less the same thing, it was thought that it was best to bring them together under one umbrella. The first one was the Parliament Integrity of Members Act 1973, and that was the body, which was a commission, that Andrew Holness would have been submitting his statutory declarations from 1997 until 2017. As well as the other parliamentarians and senators. The Parliament Integrity of Members Act was passed in 1973, and that would have been under the Michael Manley government. Then you have the next entity, which was also investigating corruption. That one was the Contractor General under the Contractor General Act of 1983. That was passed by Papa Eddie, and that was passed in order to investigate corruption among other things, when it comes to government issuing contracts, right? So they wanted to make sure it was fair and there was no cronyism, no corruption, no bribery, nothing like that involved. So he set that one up in 1983. The third law that was investigating corruption was the Corruption Prevention Act that was established in 2001 by PJ. So you have these three agencies. They were all, by the way, called commissions, and they were investigating various aspects of corruption. One, looking into the corruption of the parliamentarians. The second one, the Contractor General Act, would have been looking into the government contracts that were being given out. And then the third one, the Corruption Prevention Act of 2001, was looking now into the other public officials, the other persons who serve in the government, whether in the civil service or in the public bodies. That's what they were investigating. So the decision was made to make them into one commission, and the law was passed by Holness himself. I seem to recall that he was pressured into passing the law by people in the private sector, among others, even though they were complaining that there were aspects of the act that didn't look quite right and needed some more work. They were told to pass it, so then pass it. Now it is instructive to know, I'm just putting this out as a information, facts, that between 1997 and until 2017, even in the report that was sent to Parliament on Andrew Holness about false statement and all them sitting there, they said that he had been sending in his statutory declaration every year on time since 1997 until 2023, which is when the most current one is due, right? In all that time, for 26 years? Yes, 26 years up to 2023. 26 years he has been submitting his declarations. The Integrity Commission, this current one, came into effect 2017. The first one they would have seen would have been 2018. They would have seen the one for 2019, and they would have seen the one for 2020. And then up came 2021. And they found out that he had 3 accounts that he did not declare. Well, he gave an explanation, and they more or less say, okay, fine, we accept that. And what was the explanation? There were 3 dormant accounts. Wasn't using them, no big deal, right? So he closed them, and that was that. About 3 months later, then come back again and said he had 4 accounts that he did not declare. It turned out, after it was referred to the Director of Corruption Prosecution, that she found out that the 2 accounts belonging to his mother, which the investigator wanted her to prosecute Andrew Holness on, turned out that Andrew Holness was not a joint holder at all. Her name alone appeared on that statement, right? So 2 accounts only that he was joint holders on that he failed to declare. He gave an explanation that the accounts were not his, the 2, the one with his father and the one with his constituents, and that he had nothing to do with whatever money that is in it. And the Director of Corruption Prosecution decided that she was not going to prosecute because, according to her, she had no evidence before her that would refute anything that the Prime Minister said, and so that was that. The question now is, why is it that the Integrity Commission is not certifying his 2021 statutory declaration? Because there is no question of any illicit enrichment there. The illicit enrichment claim or investigation was for the 2022 statutory declaration. So this is the reason now why he decided to go to court, because it's the only thing he can do is to go to court and for the court to give him some remedy. And the law only allows him to pursue that remedy through the process known as a judicial review. And Dion is going to explain all of that to us shortly too. So let us rejoin her. I just gave it that background. Basically to say that in 24 years, there was no issue with his declarations that he has been filing from 1997 up until 2021. These people just come and they are finding an issue. So naturally, we have to wonder about that. Is it that the other body, the Parliament Integrity of Members Act, that commission was not doing them work? Or is it something else? We don't know. We're going to listen to Dion now as she further explains what the ruling was about on Friday.
So the Integrity Commission had published a report on the Prime Minister's statutory declarations and why it was they hadn't certified it. So the Prime Minister took the Integrity Commission to court to try to force them to certify his declarations for 2021 and 22, and also to try to get the report quashed or thrown out. He's asking for what is called judicial review of the Integrity Commission's actions. Now, judicial review is not an appeal from the decision that was made by the Integrity Commission. What it is for the court to look and see and decide whether the Integrity Commission made its decision in a way that was fair and according to law.
Thank you for that, Dion. But my peeps, let's see if we can get some further clarity. Not that she hasn't tried, but we just want to be sure that we have a full picture in our mind as to what is going on. So I ask, what is a judicial review? It says here, judicial review is a legal process that allows a court to review the lawfulness of a decision or action made by a public authority. So it is not, a judicial review is not about what it is that Grace Kennedy is doing, or what it is that some other company is doing, right? It's only about public authority. And the public authority may be the civil service as well as the public bodies. Any aspect of government, with the exception of the parliament, I do believe, but any other authority, when they make a decision, they have to act according to the law and the regulations that governs them. Whenever they act, and the members of the public or anybody at all, maybe another company or maybe another public body, who knows, they believe that they act outside of the authority, then they bring the matter to the court to have a judicial review. And the judge in that judicial review will be looking at the decision that was made and then determine whether the law that governs the body the law was broken or they were acting according to law. That's what that means. Not only the decision, but the actions that they take. So let me continue reading. It says, it's a way to challenge the process used to make a decision rather than the decision itself. Now that is a curious thing, because if there is a process to be followed and they fail to follow that process, then that a decision that they make can be thrown out. You follow? Because that's what government is about. It's not just about the power, but they have to follow what the law says the process is. You follow? Once they go outside of that and do something else, they're in a problem. So that is what apparently Holness is challenging, the process that came to the conclusion that they had about his statutory declaration. And that process is them deciding, after them finish the investigation and table it in Parliament, that they're going to now send the report to the FID to do investigation, when them had all the time in the world to have done that. So that is one of the process he is pursuing in this judicial review, I do believe. Now, I want to give you some more information about a judicial review before we continue with Dion. So it says, here are some things to know about judicial review. What is the purpose of it? How does it fit into our legal process and affect our lives? Well, it says the judicial review ensures that public authorities make decisions properly and in accordance with the law. It also protects civil rights and liberties by striking down laws that violate the Constitution. Oh, so they can strike down laws too. Yes, so you see the reason for it now, right? You have a situation where you have the parliamentarians and they make the laws. They make the laws, they establish these public bodies and give them authority. And if they are allowed to just make a decision, any decision, whether it is in accordance with law or not, and you have no mechanism for having that reverse, because remember, once they make the decision, you can't do nothing more than comply. If there is no mechanism for reversing any decision that they make, then guess what? That is what is known as tyranny. So the judicial review is an opportunity for the individuals who may feel that they were wronged by a decision made by a public authority, whether that public authority is a statutory body or, one of those public bodies, land valuation, titles office, any one of those public bodies that make decisions from time to time, including the parish councils. The judicial review gives the public and companies, which are legal entities, an opportunity to have the decision made, reviewed by the court. That's the long and short of it. Now, what happens though when the court make the decision, or maybe the better question to ask is, what kind of decision can the court make to assist individuals who may have been wronged? But before I get to that, there is this matter of who can apply. It says here, to apply for judicial review, you must show that you were affected by the decision. You personally, can't be anybody else. And that your case has grounds, meaning you have a good chance of winning, right? That's what you have to show. Great. So now the most interesting question you want to know is, what would happen if Andrew Holness wins? What happens if you win at the judicial review, meaning that you got the court to agree that you were wronged? This is what it says. If you are successful in applying for judicial review, the decision is quashed. This means the public authority must reconsider the matter and correct the legal mistake. So once the judge is going to make some, let's say for argument's sake, the judge look at the case, look at the report, listen to the arguments, do her own research and come back with her, laws them to back her up, her arguments, because that's what the judge have. She have to back up your argument, if it's a female judge. And having done so, made a ruling to quash the decision that was made, because it said the decision is quashed. So the public authority made a decision and the judge quashed that decision. They're saying that it means that that public authority must reconsider the matter and correct the mistake, because the judge in her ruling will be saying what the law is and where they went wrong, if they went wrong, and what mistake they made. So even though the judge is not giving them an order to say, this is quashed and you must correct it and you must do this, the judge is not going to do that. Once it is quashed, that means to say the decision is no longer lawful. It no longer exists. So they are going to have to now make a decision. And what they will do is take the advice of the court and fix the problem. Whatever the judge suggested, that is what they will put in place. And that is that. You get it? So let us listen to Dion and I'll come back with a few more words on this.
Just a reminder as well that judicial review is a two-stage process. So if you want to apply for judicial review, you first have to apply for leave or permission to apply for judicial review. A little convoluted, I know. So if the court grants you leave or permission to apply for judicial review, then you now move on to the next stage, which is a full hearing of the issues. And the whole idea is to get rid of the cases that are a waste of time, that don't have any substance to them. So the Prime Minister was at the first stage. He had applied for leave to apply for judicial review. The Supreme Court has now ruled on his application and has granted leave or permission in relation to part of the application and refused part. So let's break down what happened. Dr. Holness and the 3 companies associated with him were asking the court for a whole heap of things, 28 remedies in all. Not going to go through all of them, don't worry, although in my videos I did. So you again, look below and you can look at the previous videos I did that went into very great detail in terms of what the Prime Minister was asking for. So the Prime Minister wanted some orders of certiorari. These are also called quashing orders, and what they mean is orders to throw out or nullify a decision that had been made by the Integrity Commission. The Prime Minister and his team are also asking for orders of mandamus. Now, these are orders that would have the court making an order to compel the Integrity Commission to do something. Then they wanted some declarations for the court to make certain rulings on issues of law. As I said, the court granted some of what the Prime Minister was asking for and refused some. First of all, what did the court grant permission for? The court granted leave to apply for judicial review, to apply for an order quashing the findings, conclusions, and recommendations in the investigation report on the Prime Minister's statutory declarations. Now, this is a report that raised the question of illicit enrichment and raised the question as to whether the Prime Minister's income was sufficient to explain his wealth. So you can understand why he would want this particular report quashed.
Now, I am compelled to pause Dion here for a moment to make what I believe is a correction. She had said that this is the report that she's talking now about the investigator's report, which was tabled in Parliament. And she's saying that this is the report that raises the question of illicit enrichment. And then she went on to say this, and raised the question as to whether the Prime Minister's income was sufficient to explain his wealth. Now, it is the use of the word wealth. And then she went on to say that you can see the reason why he would want it quashed. Now, what the hell is she implying? What is she implying? That the Prime Minister, she's implying that the Prime Minister has unexplained wealth, as she called it, and therefore he is naturally expected to want to see the report quashed. That's basically what she's implying. But let us look at the section of the Corruption Prevention Act. It's section 14.5, which deals with illicit enrichment. And in the second paragraph, it says, the section states that where a public servant, A, owns assets disproportionate to his lawful earnings, and B, upon being requested by the Commission or any person duly authorized to investigate an allegation of corruption against him, to provide an explanation as to how he came by such assets, he fails to do so, gives an explanation which is not considered to be satisfactory, he shall be liable to prosecution for the offense of illicit enrichment. So what is illicit enrichment? When your assets are disproportionate to your lawful earnings. Now, if you recall, the matter was referred to the commissioners by the Director of Information and Complaints. And what he said was that there was a 4.4 million unexplained wealth. Now, this was after they had readjusted his statutory declarations because 4 accounts were found that he did not declare before. In 2 of the accounts, his mother's accounts, there were a little over $4 million. And we are talking now about the amended 2021 declaration that Holness had submitted. They found that there were 4 other accounts that he did not declare, right? Remember now, the mother's account his name not on that, but they didn't know that at the time. So the Director of Information and Complaints, that's the one who receives the statutory declarations and examine them, made a referral to the commissioners and said, look, you need to investigate this 4.4 million. And they then sent the referral to the investigator for him to go and look into the 2021 statutory declaration for 4.4 million, what they would think was the appearance that that would have been certainly disproportionate to his lawful income. For that year, his income was 6.7 million, if I remember right, which was his salary, net salary as a prime minister. Follow? Good. So that was what happened. We don't hear nothing more about that. We don't hear gunfire about that. What we found was that the Director of Investigation was now looking into his 2022 statutory declaration. Now, we found out at Jamaica 411 why there was no further need to look into that. What was that? Because the 4.4 million, which was not Holness' account, that's his mother's account, that was what pushed up his assets. You follow? So the investigator would have discovered that the 4.4 million that gave the appearance that that was his assets was not assets at all. It was his mother's account that they had added to his declared amount and pushed the figure over. So he abandoned that. So it comes now to 2021. And when they looked at his declaration and they did some calculations, they came to the conclusion that there was a $1.9 million discrepancy, meaning that his lawful income did not cover that 1.9 million. Except we at Jamaica 411 saw the flaw. What they did, because he was now putting all of his money, including his salaries, into the company called Imperium, what they did was to take the expenses of Imperium and took it away from his income, which would have been his salary. That was added as capital. Then you have the dividends and interest and so on that he would have earned from the stocks and bonds that the company is holding for him. And they took the expenses of something like 9 million away from that, which brought the figure down as net profit to around 2 million. When they added that 2 million net profit, they then add that to his 6.7 million salary. And when they took it away from the increase in his assets, which was 9 million, that is where they got the $1.9 million discrepancy. But here's the problem. It was because they took the expenses out of the income of the company, why they ended up with that 1.9 million deficit. Let me put it to you this way. Had he not put all his assets in this company and had it in his own personal name, right, he would have received the dividends on those stocks and bonds and interest and all them kind of something there, right? Which amounted to, honest, I believe was $6 million, $5 to $6 million. They would not have excluded or took away from that income his home expenses. Remember, him have home expenses and things that he spent for the year. So if you don't do that for you as a person, why would they have done that for the company? Yes, you're supposed to do that for the company if you're doing some calculations for, taxes and so on. But when it comes to you trying to determine whether or not there is unlawful earnings, you have to deal only with the earnings from the company and the earnings from his salary, and then you minus that from the assets that increased. If you don't do that and you start taking out the expenses of the company, you will always find that he will always be in deficit. Not just him, but others too, because it's diminishing the earnings by taking out the expensive. I don't know if you follow what I'm saying. right? So it is because of that. So I'm sure when it goes to the court and they point that out, to the court, that the company made $6 million. He added 6 million, that amount to 13. It was 6 point something, 6 point something for the company. That's $13 million, right? That is what he earned for the year. And then now the assets increased by 9 point something million. Therefore, he was not in the red, as they believe. I wonder if you follow me. You get it? Great. So let me correct Dion. She said wealth. Wealth is not just assets. It's a whole heap of thing, and it's an accumulation of what you have. It's the extent of what you have. And therefore, they were not questioning his entire wealth. They were only questioning the declaration that he had made in terms of that particular year, and that it appeared to them, based on the calculation that they did, an accounting calculation, that the assets increased in that year, and the income that he received for that year did not explain it. That was what that was about. So what she was saying was factually incorrect. So I wanted to correct that. So let's listen some more, and then I'll come back with my closing.
The Integrity Commission's legal team said they didn't think this application would succeed, but they didn't oppose it. And I should say, even if they hadn't opposed it, the court would have granted leave in relation to this part of the application anyway, because the court said there was enough evidence to satisfy what is called the threshold test, meaning that there was enough evidence to show that there was an arguable case with a realistic prospect of success. In other words, there's enough evidence there to show that this particular part of the application wasn't a time-wasting exercise. The court also granted leave to apply for judicial review, to apply for an order quashing the Integrity Commission's special report. Now, this was a one-page report that said, among other things, that the matter of the declarations had been referred to the Financial Investigations Division, and that there would be no finality in the matter until the Financial Investigations Division had finished its work. What the court said is that the special report was so connected to the investigation report on the statutory declarations that it too was tainted with any illegality that the investigation report might have. So since the two of them were so interconnected, the court said if it granted leave in relation to one, then it would have to grant leave in relation to the other, and that's what it did. Then the Prime Minister wanted some orders of mandamus, as I said. These are orders that the court can make compelling the Integrity Commission to do something. So the Prime Minister was asking for an order compelling the Director of Information and Complaints to examine Mr. Holness's 2022 and 2023 statutory declarations. The court refused this, saying that the director's unchallenged evidence was that he had examined the Prime Minister's statutory declarations for 2021, 2022, and 2023. Since courts don't believe they must waste their time, or to use their language, act in vain, the court said it would not direct the director to do something he had already done. The Minister also wanted an order compelling the Director of Investigations to recommend to the Integrity Commission that the Prime Minister be exonerated of culpability in relation to the 2021 and 2022 statutory declarations, meaning he wanted the court to tell the Integrity Commission to say he had done nothing wrong. The court refused. The court said it cannot and will not usurp, meaning take over, the decision-making powers of public bodies and public officers, and therefore, on that basis, refused leave to apply.
And you remember why? Because it says here, what happens when you win? It says, if you're successful in applying for judicial review, the decision is quashed. They cannot order the public official to do their work. They can only quash the decision, and then it means, of course, that the public authority must reconsider the matter and correct the legal mistake. You follow? Yes. So the judge, as Justice Jarrett said, can't go tell a public official how to carry out them work. And now she did do the investigation. You follow? Great.
Finally, the Prime Minister was asking for a number of declarations. Among the most significant of those is the one asking for the Integrity Commission Act to be struck down, and also asking for the section of the Corruption Prevention Act dealing with the offence of illicit enrichment of public servants to be struck down. And I say those are among the most significant because Dr. Holness was Prime Minister when the Integrity Commission Act was passed. Also, the crime of illicit enrichment is supposed to help to deter public servants from corrupt activities like taking bribes. Anyway, the court said those types of declarations don't need the permission of the court to go ahead. The same for the Prime Minister's application for an order to end the investigation into his statutory declarations. One of the Prime Minister's lawyers told me that they will be going ahead with the applications for those declarations, so it's going to be really interesting to see what happens there.
So I think we can thank Dion Jackson Miller for her assistance in helping us over here, because we're not a lawyer. We can only use with common sense, and this one did a bust with common sense. We not tell no lie. This one did beat. But we can thank her for her explanation, and also for taking the time and trouble to try and explain as best as she could. Now, in terms though of the statutory declaration, when I was trying to explain about the illicit enrichment part of it, however you strike it, you cannot own assets except through earnings. Whether the earnings were legal or illegal, you're going to use money to buy assets, it has to come through some form of earnings, right? And the one thing that the investigator failed to show in his report is that Holness had unlawful earnings. You see, just to say that he has the assets, he went and he asked him about his every single asset type that Holness had. He asked him to explain where the money came from, and he was able to explain where the money came from. So if you cannot show that the earnings that purchased the assets came from illegal source, or the asset was stolen, then the investigator ought to have realized there must have been something wrong. I wonder if you understand me, right? If the assets was acquired with income, he cannot explain, this is Holness, where it came from, then you have an argument. But he could explain where his earnings came from. And the assets that you identify that he declared, you haven't found anything else except for the mother's account. It turned out that his name was not on his mother's account in the first place. Right? So he said, this is my income. And he showed you evidence of the income. You say no, here are the assets that you declared. If there are 10 of them, you ask him what's the source of the money, and he showed you the source of the money for all 10. And you have not been able to show that the source of that money was illegal, because it was coming from him selling shares, selling bonds, his salary, and loans that he took, as well as dividends he had earned on the stocks that he owned. Those were the sources of the income that he had. Then, therefore, when you draw the conclusion that the increase in his assets was disproportionate to his lawful income, you ought to have realized that there is something wrong. You have his income legally made, you have his assets, all of them legally made, and it's all of them that is declared, right? And it's all of them that you applied your calculations to. And therefore, how did you end up with a 1.9 million? It must be something wrong with your sums, unless you can show that the assets were illegally gained or the income was illegally gained, and you had no evidence of that. I wonder if you understand me, my peeps. In other words, The evidence that the investigator had before him said that Holness's assets were legally obtained and his income legally made. So, faulty thinking is, to me, what has brought this matter to where it is. But let the court make its own decision. I'm sure the judge is going to be looking at all of what we are saying, because I would expect that the attorneys will be pointing out to the judge, and then the judge will draw her conclusion based upon the evidence as well as precedents. And I keep saying her, it could well be a he. Anyway, that's all I have for you today. I hope I have not confused you. I hope I've made everything clear. And I want to thank you for giving the video a thumbs up, subscribing, sharing, and leaving your comments. Until next time, you take good care of yourselves and walk good.